So, very good evening, friends. Today we'll be discussing the information utilities. So, as we know, as on date, there is only one information utility, National E-Governance Services Limited, NESL. And what the law says that no person can act as IU without a certificate from the board. Now, the board naturally has the option either to accept the application or reject the application. Now, suppose you obtained the certificate of registration as information utility by false statement or misrepresentation, or you fail to comply with the regulations or bylaws, or you contravene the provisions of the act or rules, or any other ground as may be specified, then the application might be rejected. And no order in this case shall be passed by any member except whole-time member, and no order shall be made without giving opportunity of being heard. So in case your application is being rejected, then you have the opportunity of being heard. Then appeal lies with the NCLT in case your application for registration as information utility is refused. Now, there are provisions for submission of information by financial creditors, operational creditors, other persons. And any person, financial creditor or operational creditor, shall submit the financial information to IU, and he can access the same also. And the fees for both accessing the information has to be same. And any person who intends to update any security error in financial information, he can also make an application to the information utility. What are the conditions for an information utility to be formed? It has to be a public company. Like in IPA, we saw that it has to be a Section 8 company, but here it has to be a public company. The sole objective should be to provide a service under these regulations. There are conditions on shareholding also. So, what is the exact section? Please tell me. Kya section is come? Information utility?
209.
209.
208 is it?
208.
209 sir.
208
209, sir.
209 is the section.
Yes, sir.
209 is.
So regarding shareholding also, what the regulation says, that no person shall hold directly or indirectly 10% of the paid up equity capital or voting power. This is given in Regulation 8, Chapter 3. And if you are a government company, you are a stock exchange, depository, bank, insurance company, public institution, then you can hold up to 25%. And if you are central government or state government, then no such restriction. There are provisions regarding governing board also, that more than one half of the directors shall be independent directors, and no meeting shall be held without the presence of at least one independent director. Yesterday, we saw some of the provisions regarding IPA. So, if you compare the regulations relating to IPA and information utility, more or less they are similar, particularly regarding the governing board, regarding the independent director, shareholder director, etc. Minimum net worth requirement is 50 crores and it should not be under the control of person resident outside India. Not more than 49% of its paid up capital or voting power is directly or indirectly held by persons resident outside India. And the utility itself, its promoters, its paid up capital, voting power. So you have to see the criteria of fit and fine, then integrity, absence of conviction, financial solvency, etc. So all these criteria have to be satisfied once you want to get yourself registered as an information utility. Application has to be made to the board in Form A plus non-refundable fees of 5 lakhs. And renewal is at least 6 months prior to expiry in Form A plus non-refundable fees. This fees is for registration or for renewal, but there is an annual fees also of 50 lakhs, I think. And board shall act on the application within 7 days of receipt. If it is satisfied, it will issue certificate of registration. And if it wants to reject or some further details are required, then within 45 days it will communicate the reasons that why it wants to reject, or there are some other clarifications required, pending which the certification, the registration has been put on hold. If it is satisfied, it will issue the registration in form B within 60 days of the receipt of application. But if it wants to reject or further details are required, then it will give the opportunity to be heard within 15 days of the above communication. This communication has to be made within 45 days. And after acquiring further details, then ultimately it will accept or reject the application within 30 days. And certificate of registration is valid for 5 years from the date of issue. Then annual fees of 50 lakhs is to be paid within 15 days of issuing the certificate, and every year thereafter within 15 days from the end of each year. So here there is a question that this registration, this annual fees has to be paid. Just a minute. I noted down such question. Yes. So this 50 lakhs fees, there is a question for you. This fees of 50 lakhs is to be paid after intimation of registration or renewal, or before intimation of renewal, before intimation of registration or renewal. This has to be paid. The regulation 6 says it has to pay a fees of 50 lakhs rupees to the board within 15 days of receipt of intimation of registration. So it means it has to be paid after the intimation of registration or renewal is received. And then it says there is an example also that okay, if you pay within 15 days, then no interest is payable. But if you pay after 15 days, then the interest at the rate of 12% is payable for the delay. So the regulation says pay a fees of 50 lakh rupees to the board within 15 days of receipt of intimation of registration or renewal from the board. So it means first you will receive the intimation of registration or renewal, and then you will pay the fees of 50 lakhs. You can obtain in principle approval also. And for certain conditions, in certain situations, prior approval of the board is required. So if person is acquiring more than 5% of the paid up or voting power directly or indirectly, then prior approval of board is required. If there is a change in control or management, if there is a merger, acquisition or restructuring proposal, if there is a sale, disposal of whole or substantially the whole of the undertaking, or there is a provision for voluntary liquidation or discontinuation of business, then in all such cases, the information utility has to obtain the prior approval of the board. And there is a condition for intimation. It will intimate the board if a person holding more than 5% of paid up equity or voting power ceases to hold within 15 days. So there is a provision that in case a person ceases to hold also, then also he will intimate the board. So there is a provision in subsection F of sub-regulation F of regulation 6 regarding prior approval for certain cases. But in case you cease to hold at least 5% equity, then there is a provision for intimation. It is given in 6G. Then in principal approval also, application plus fees of 5 lakhs, approval is valid for 1 year. If you want to amend the bylaws, provisions are similar to those of change in the bylaws of IPA. In IPA also, if you want to amend the bylaws, so it has to be done with 75% votes, 3 times the votes cast in favor than against. Then you have to file this resolution with the board within 7 days of approval, and amendment shall effect on 7 days of receipt of approval, and IU shall file a printed amended bylaws within 15 days. So provisions regarding IPA and this IU are similar regarding amendment in bylaws. Then there are provisions regarding this registration of user. A person shall register for submitting information or accessing the information. So unless you are registered, you cannot submit the information or you cannot access the information. And if you are registered with an IU, then you shall not register itself with any IU again. There is a provision that, okay, one can register himself or herself with one information utility only. And information utility shall accept information submitted by user in Form C. On receipt of information, IU shall authenticate and verify. So there is a provision for, suppose the banker intimates to the IU that, okay, such and such person has availed loan. Now the IU will shoot a corresponding mail to the person who has availed the loan that, okay, we have been informed by the banker that you availed this loan. So whether you have indeed availed the loan or not. Now there are two situations. Either he will accept or he will deny or he will keep mum. So these are the three conditions. So based on these, there will be marking of red, yellow or green signal. If the person altogether denies that, okay, this information is wrong, I have never availed any loan, then red mark will be there. If he keeps mum despite three reminders, then yellow. So it will be deemed that he has accepted. And the third situation could be that he accepts that, okay, I have availed the loan. So then it will be marked green. So red, green and yellow markings are done for the authentication of information. And no information is fed unless it is verified from the corresponding party. Then there is another provision that the information utility shall store all information in a facility. The server has to be located in India. Who can access the information? The access of information can be by the user who has submitted the information, partners to the debt, and the host bank, CD and its auditors, IP, board, adjudicating authority, or person authorized under any law. Then there is another provision that an IU shall not outsource the provision of core service to a third-party service provider. And the fees charged for access to information shall not exceed the fees charged for submission of information to IU. Then Form A is for application for certificate of registration. Form B is certificate of registration issued. And Form C is submission of information to IU. Now let us see some of the regulations also regarding this IU.
Sir,
Yes, please.
it means that any third person cannot access the information, right, sir?
No. He can access, but he has to first register himself. So first of all, you have to provide your credentials, your PAN, Aadhaar, etc., whatever information is required, so that you are a genuine user. You can access on payment of fees, definitely.
Okay, sir.
You go to NESL website and then you will come to know everything is there. Registered user, operational creditor, financial creditor. Bankers are periodically informing the information utility regarding the loans availed, charges created, charges vacated, etc. And this information is being fed. Then whenever we are reading IBC, we might be reading that, okay, the operational creditor will submit this information to information utility, and based on that information itself, it might be presumed that, okay, this operational debt exists. So this is in the process of development, and ultimately the idea is that the information regarding loan, regarding debt, etc., will be verified from the information utility itself, and not there will not be any need to furnish documents. Suppose a financial creditor wants to prove his claim, so he has to give the copy of the loan agreement, etc., the charges created, whatever the security is having. If all this information is available with the information utility, then it can be directly verified from there. That is the ultimate idea. But in the meantime, till such development takes place, the claimants are required to produce proof. So these are the, yes.
Sir,
Yeah.
rather we can say that IU cannot do the outsourcing for the garner of the getting information on behalf of IU. मतलब थर्ड सर्विस उन लोग के लिए कोई काम नहीं करेगा, थर्ड पार्टी, है ना सर?
ऐसा है जो कोर एक्टिविटीज है, the core activities of IU cannot be outsourced to a third party service provider.
Yes sir.
तो अब ये थोड़े से रेगुलेशंस देख लेते हैं, मेन रेगुलेशंस पे क्या क्या लिखा है. थोड़ा बहुत हो सकता, कई बार क्या होता है, these regulations are amended from time to time, so you can compare it with the regulations which are applicable for your syllabus. Let me see if something is important here. जो भी important होगा उसको हम देख लेंगे. Eligibility, this we have seen, 50 crores, then 5%, 25%, 100%, this we have already seen. Regarding this fit and proper, this is important. ये क्या बोलता है? For determining whether a person is fit and proper under these regulations. Now, what are the criteria? That okay, no person can hold more than 5% directly or indirectly unless you are a stock exchange, depository वगैरह, है ना? That we have already seen. तो अब क्या है? वो क्या बोलता है कि भाई for determining whether a person is a fit and proper person under these regulations, the board may take account of the relevant considerations. क्या considerations? Including integrity, reputation, and character, absence of conviction by a court for an offense, provided that a person may be considered fit and proper if he has been sentenced to imprisonment for a period of less than 6 months. Now, suppose you have been imprisoned. There could be two scenarios. Number one scenario is that okay, you were sentenced to imprisonment for a period of less than 6 months. Second is you were sentenced to imprisonment for more than 6 months but less than 7 years. And third could be 7 years or more. So in the first scenario, if any person has been sentenced to imprisonment for a period of less than 6 months, then he may be considered fit and proper, despite the sentencing of imprisonment for a period of less than 6 months. This is first. Second, a person shall not be considered fit and proper. Now, second scenario is the imprisonment is not less than 6 months, but less than 7 years. And a period of 5 years has not elapsed from the date of expiry. So, another case is there that a person was sentenced to imprisonment, say, for 2 years, but a period of 5 years has not elapsed from the date of expiry of the sentence. Then he shall not be considered fit and proper person. Third is the scenario when he has been sentenced to imprisonment for 7 years or more. In that case, he will never be considered fit and proper. So, first condition is less than 6 months, may be considered fit and proper. Second condition, sentenced to imprisonment for not less than 6 months, but less than 7 years. Then he shall not be considered fit and proper, provided a period of 5 years has not elapsed. So it means if someone was sentenced to imprisonment for say 2 years, but period of 5 years has elapsed, then he may be considered fit and proper. And third is the situation when a person was sentenced to imprisonment for 7 years or more, then in that case, he will never be considered fit and proper. These days, they are not asking, but earlier days, they were asking questions on this. Absence of restraint order in force issued by a financial sector regulator or the adjudicating authority and financial insolvency. Now, application, this has to be made in Form A, and if you are seeking renewal, then you have to do it at least 6 months. Disposal of application, summarily we have already seen. कुछ इंपॉर्टेंट प्रोविजंस हैं वो जो मैंने नोट किए थे वो मैं देख लेता हूँ है तो कुछ ऐसा है कि मुझे लगता है दैट इज इम्पोर्टेंट. Conditions of registration, ये सारा आपको कहना मानना पड़ेगा. It is valid for 5 years. Okay. Annual fees 50 lakhs होगी within 15 days from the date of commencement of the financial year. Within 15 days of receipt of intimation of registration or renewal from the board. ठीक है भाई, एनुअल फीस है आपकी. आपका रजिस्ट्रेशन वैलिड है फॉर 5 years. ठीक है ना. जब आपने एप्लीकेशन दिया उस टाइम तो जब आपको रजिस्ट्रेशन का इंफॉर्मेशन मिल गया तभी आप दोगे नेचुरली. ठीक है ना. बाकी अगले सालों में इन नेक्स्ट ईयर्स सपोज इट इज वैलिड फॉर 5 years तो आपको 50 lakhs देना ही है, तो आपको विद इन 15 days वो देना. ठीक है ना. विद इन 15 days फ्रॉम द रेट ऑफ कमेंसमेंट ऑफ द फाइनेंशियल ईयर. तो बाय 15th April यू हैव टू पे. ये फिर एग्जांपल दिया हुआ है, खास बात नहीं है. Another point was regarding seeking prior approval. So there are certain actions. If you want to hold more than 5%, if there is a change in control, merger, amalgamation, ये सब हमने discuss कर लिया. And there is another point regarding intimation. So you have to intimate the board if you cease to hold. If a person holding more than 5%, directly or indirectly, ceases to hold at least 5%, then also he has to intimate the board within 15 days. In principle approval का भी है, ठीक है ना? तो आपको in principle approval भी मिल जाएगा. That is valid for period of 1 year. Shareholding also we have discussed, ठीक है ना? 5% आपको 10% है, और if you are a government company, stock exchange, depository, bank, insurance company, public financial institution, तो उसमें 25% है, और अगर state government या central government है तो फिर आपका 100%. अच्छा, ये कुछ 3 years का है. 3 years from the date of the registration. वो initial years में था जब आपका before, if you are registered before 30th September, तो ज्यादा मतलब का नहीं है. Regarding this composition of governing board, this we have discussed. IPA में भी हमने discuss किया था. Similar provisions are there, ठीक है ना? IPA में भी यही है कि managing director होना चाहिए, independent director होना चाहिए, shareholder director होना चाहिए, provided that more than half of the directors shall be citizens of India and shall be residents in India. ठीक है? So what you can do, you can compare both the regulations regarding IPA, इसके बारे में जो composition of governing board, और यहाँ पर देखेंगे आपको same है. अगर कुछ different है तो उसको आप note कर सकते हैं. The managing director shall not be considered either an independent director or a shareholder director. ठीक है? हाँ, employee भी जो है shareholder director बन सकता है. ये सारे provisions हमने कल भी देखे थे, सेम ही है, इसमें कोई खास फर्क नहीं है. एक पॉइंट मैंने नोट किया था रिगार्डिंग कंप्लायंस ऑफिसर. जैसे हमने इन आईपीए रेगुलेशंस व्हाट वी सॉ that there has to be compliance officer who will ensure compliance. So there is a concept of compliance officer here also. ठीक है? तो अब ये जो compliance officer है ये क्या करेगा, लेकिन उस केस में क्या करना था, इन आईपीए एमडी ऑल्सो साइंस अलॉन्ग विद कंप्लायंस ऑफिसर कंप्लायंस सर्टिफिकेट को, लेकिन यहाँ पर ऐसी कोई कंडीशन नहीं है. जैसे अगर वहां पर देखोगे आप कि वहां पर देयर इज अ रेफरेंस ऑफ एमडी ऑल्सो इन आईपीए, एमडी को भी साइन करना पड़ता है, बट यहाँ ऐसा मुझे कुछ मिला नहीं कि ऐसा इसको भी कुछ साइन करना है. अच्छा, अनदर पॉइंट वाज रिगार्डिंग इन 9 रेगुलेशन 9 में क्या बोला है, रेगुलेशन 9 में ये बोलता है, ये पॉइंट नंबर 9, it says a cooling off period of 3 years shall be applicable for an independent director to become a shareholder director in the same or another information utility. यहाँ पर ये प्रोविजन. बट इफ यू गो टू द आईपीए रेगुलेशंस, वहां क्या बोलता है, वहां बोलता है for an independent director to become a shareholder director or an independent director. दोनों बातें वहां लिखता है, लेकिन यहाँ पर क्या लिखा है, a cooling off period of 3 years shall be applicable for an independent director to become a shareholder director. वहां to become a shareholder director भी लिखता है और independent director भी लिखता है. तो this also मुझे ऐसा लगा कि भाई ये थोड़ा सा डिफरेंट है यहाँ. अच्छा, उसके बाद में ये तो हो गया, वही 55 ईयर 65 ईयर सेम है जो आईपीए में है ना, बिल्कुल सेम है जो कल हमने पढ़े थे अभी. अच्छा, रिगार्डिंग वेरियस कमेटीज, इसमें क्या है, बोलता है कि एक तो रेगुलेटरी कमेटी बनेगी, बहुत सारी कमेटीज हैं इसमें. सो फर्स्ट ऑफ ऑल देयर इज अ रेफरेंस ऑफ रेगुलेटरी कमेटी, और कंप्लायंस ऑफिसर शैल रिपोर्ट टू द रेगुलेटरी कमेटी. ये फिर कंप्लायंस ऑफिसर का मैंने बता दिया. ग्रीवांस रिड्रेसल पॉलिसी हैज टू बी देयर. देन टेक्निकल स्टैंडर्ड्स, टेक्निकल कमेटी. हाँ जी
Sir, one more, I think that important difference in composition of governing body, sir. In that, in IPA, I think
मेरी मीटिंग जल्दी बाद में बात करते हैं, 1 घंटे बाद. हाँ जी, बोलिए.
Insolvency professional will not form part of the governing body, sir, but it is not given in IU like that, sir.
Okay.
Mentioned.
अच्छा, रेगुलेशन नंबर?
Sir, that is 5, sir, in IPA. composition of governing body.
Okay.
Oh, no, sir. No, sir. In independent director, no, I have no, sir. Completely wrong.
हेलो, मेरी मीटिंग चल रही है सर जी, 1 घंटे बाद बात करते हैं। 1 घंटे बाद बात करते हैं, एक्चुअली मेरी मीटिंग चल रही है।
Yes, sir.
हाँ जी।
Sir, in that is the person, an independent director shall be an individual, sir, and who is not an insolvency professional. It is being specifically given in IPA, sir, but not in case of IU, sir.
Okay. Okay. Thank you. And this amendment of bylaws also we have seen, 75% majority के within 7 days you have to intimate, है ना? And फिर उसको 15 days के अंदर आपको amended bylaws देने हैं। Provision for services, ये point number 17 है। से ज्यादा आपको 27 है पॉइंट नंबर। रजिस्ट्रेशन का तो सिंपल है, कोई खास बात नहीं। 27 में आपको बताना चाहूंगा, 27 में ड्यूटीज ऑफ यूजर, दिस इज इंपॉर्टेंट। व्हाट इट सेज, ए यूजर who has submitted information in form C of the schedule to an information utility shall submit the information updated as on the last date of every month in the first week of the following month, provided that information of default shall be updated within 7 days of occurrence of default. So that is the provision पहला। और दूसरा क्या है, a user shall expeditiously correct information as soon as it finds it erroneous, stating the reasons therefore. ये मेरे पास ये पहले वाला है, थोड़ा ये इसमें नहीं है। तो ड्यूटीज ऑफ यूजर यू कैन स्पेसिफिकली टेक नोट के suppose a user has submitted information in form C, then he shall update it on the last day of every month in the first week of the following. So the information
same है sir, कंपेंडियम में ऐसा ही है सर, कंपेंडियम में।
हाँ, कंपेंडियम से पढ़ रहा हूँ, हाँ वहीं से पढ़,
ऐसा ही है सर।
हाँ नहीं, मतलब मेन बात ध्यान में रखने वाली क्या है कि भाई देखो, एक तो ये है कि आपको मंथली अपडेशन करना है। द पॉइंट हियर इज, एक तो मंथली अपडेशन करना है, ठीक है भाई। आपने इंफॉर्मेशन सबमिट कर दी, ठीक है, अब आपको उसको मंथली बेसिस पर अपडेट करना है इन द फर्स्ट वीक ऑफ द फॉलोइंग मंथ। और दूसरा ये है कि अगर कोई डिफॉल्ट की इंफॉर्मेशन है वो विद इन 7 days ऑफ अकरेंस ऑफ डिफॉल्ट करना है। दैट इज द पॉइंट। अच्छा, और इसमें देख लेते हैं कुछ खास। एक 32 पॉइंट था इसमें। 32 पॉइंट में फीस के बारे में था थोड़ा सा। तो फीस में क्या बोलता है कि disclose any proposed increase in fees for the provision of services on its website. If the information utility wants to increase the fees, तो क्या करना होगा इसको? They have to disclose any proposed increase in the fees for the provision of services on its website at least 3 months before the increase in fees is effected. तो आपको prior 3 months intimation इसमें देना होगा।
सर एक इंश्योरेंस भी इम्पोर्टेंट पॉइंट है सर। 31 दिस वाज डिस्कस्ड वेदर द कांसेप्ट ऑफ इंश्योरेंस इज देयर और नॉट इन आईपी। 31 रेगुलेशन इज सेइंग।
हाँ, 31 में क्या बोलता है? एन इंफॉर्मेशन यूटिलिटी शैल मेक एडिक्वेट अरेंजमेंट्स इंक्लूडिंग इंश्योरेंस फॉर इंडेमनिफाइंग द यूजर्स फॉर लॉसेस दैट मे बी कॉज्ड टू देम बाय एनी रॉन्गफुल एक्ट, नेग्लिजेंस और डिफॉल्ट ऑफ द इंफॉर्मेशन यूटिलिटी, its employees or any other person whose services are used for the provision of services under these regulations. Actually, because people are relying on the information which is given by them. So suppose any person suffers some loss and he lodges a claim on the information utility. So in such case, the information utility in to avoid such cases, it is given by way of a regulation that okay, the information utility will take adequate assurance. So it is something on the lines of professional indemnity. भाई इंफॉर्मेशन यूटिलिटी जो है ना भाई, इसने कोई इंफॉर्मेशन दे दी, उसको रिलाई करके किसी को लॉस हो गया तो वो किससे क्लेम करेगा? इंफॉर्मेशन यूटिलिटी से। So that is why they shall make adequate arrangements including insurance. ठीक है, वरना इनको जेब से देने पड़ जाएंगे कोर्ट में, ये पॉइंट है। अच्छा, इसके बाद में एक पॉइंट इसमें आता है आपका 38 रेगुलेशन में। 38 रेगुलेशन में क्या बोलता है? 38 का 2 है पॉइंट, ये बोलता है द इंफॉर्मेशन यूटिलिटी shall not provide access to the reports, registers and minutes submitted under sub-regulation 1 to any person other than the concerned insolvency professional, board or the adjudicating authority. This is also important regulation. इसमें क्या बोलता है? ये देखिए, जो जनरल यूजर्स है, दे आर प्रोवाइडिंग इंफॉर्मेशन, बैंक्स भी है, फाइनेंशियल क्रेडिटर्स है, ऑपरेशनल क्रेडिटर्स है, all they are providing information, they are accessing information. But besides these, the insolvency professionals, they are also submitting reports, registers and minutes in respect of any insolvency resolution, liquidation or bankruptcy proceedings to an information utility for storage. Because actually we, as per the record retention policy, physical records have to be maintained for 8 years and electronic records have to be maintained for 3 years. Now where the records will be maintained? So the facility which is given by the information utility may be utilized by the insolvency professionals for this purpose. So they may submit the reports, registers and minutes. Naturally, the adjudicating authority, the board gives direction. They provide a link where all the information can be stored. So this insolvency professional may submit reports, registers and minutes in respect of any insolvency resolution, liquidation or bankruptcy proceeding. But because this information is different from the routine information, so this information is not accessible to any person other than the concerned IP, board or adjudicating authority. That is important. तो इतना ही था इसमें, रेस्ट यू कैन गो थ्रू। और आपका कोई स्पेसिफिक क्वेश्चन हो तो इसमें लिख सकते हैं। तो देयर इज अ प्रोविजन फॉर disciplinary proceedings also against the information utility. So disciplinary proceedings can be taken under section 222 against the IP, IPA or IU. Rajshekharan ji, you were asking something.
Now, examination question I faced actually. The information utility hold the information as a trustee, holder, agent or custodian.
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 Custodian. It's an examination question actually. Custodian is the right answer.
Right.
Hold the information as a custodian.
Okay. Why not trustee?
Custodian means store the information, sir. Store the information as a he's in a responsibility. Yes, more than trustee, more than custodian is the father.
Okay. Regarding disciplinary proceedings, so in disciplinary proceedings can be taken against the IU also. और वही सेम प्रोसीजर है, शो कॉज नोटिस वगैरह सब सेम है. And appeal in this case is to NCLAT. But in case of IP, the appeal is to membership committee. In case of IPA also, appeal is to committee only, membership committee. यहाँ वो NCLT किसमें था, वो NCLT का था, किसको था अपील? IPA में.
IPA NCLT sir.
NCLT, हाँ, और यहाँ पर है NCLAT.
IU only NCLAT.
हाँ. अब इसके बाद दोबारा अपने वही पुराने वाली पर चलते हैं. ये हो गया हमारा. Insolvency professional entity. So there are provisions regarding insolvency professional entity also, वो भी आप देख लीजिएगा. Now regarding this inspection and investigation provisions, so they are similar. IU के अगेंस्ट में इंस्पेक्शन हो, IP का हो, IPA का हो, ऑलमोस्ट सेम प्रोविजन है. क्या प्रोविजन है? सपोज authority, IBPI, wants to undertake inspection. So the inspecting authority, they will appoint an inspecting authority. That inspecting authority will provide at least 10 days notice before commencement of inspection. Okay? However, they may reduce the notice period by recording reasons in writing. If they are apprehensive that, okay, he may remove certain records, then that notice period may be dispensed with also. But normally they give 10 days notice, both in case of inspection as well as in case of investigation. So first of all, an interim inspection report is given to the board. And if the board is satisfied that there is gross violation of provisions or rules, then the matter is referred to the disciplinary committee. And this it may pass an interim order which shall lapse on expiry of 90 days. Okay. Now, there is a concept of draft inspection report. And this draft inspection report is given to the service provider also. He could be IP or liquidator or IRP or RP, whatever. So this service provider, for its comments, it is to be given within 15 days of receipt. He has to give his comments. And a copy of the draft inspection report is also submitted to the board also. And based on the report, board may conduct the investigation also. Investigation may be resorted to independently, and investigation may start after the inspection also. In both the situations, investigation can be started. And suppose investigation has started, then also 10 days notice will be given before commencement of investigation. That period may also be reduced. And investigating authority has got more powers. So they can keep custody of any record also up to 6 months. And thereafter they shall return, and they may apply to court for order for seizure of records also. Then in that case, the provisions of search and seizure will apply. Investigating authority, what they will do, they will submit the interim inspection report to the board. But there is no such provision to provide the copy of the interim investigation to service provider, like interim inspection report. In case of interim inspection report, copy is provided to the service provider also for comments, but not in case of interim investigation report. And if on receipt of interim inspection report, the board is satisfied, then that there is a gross violation, then they will start the investigation. At this, all these matters have to be disposed of within a period of 180 days. So there could be a situation where someone suffered a loss also. So if someone has suffered a loss, then he has to lodge a claim in Form A, and the amount will be recovered from the service provider. ये तो सारा हमने देख लिया, और आगे देखते हैं 96. ये मोटा मोटा हमने कवर कर लिया इन्वेस्टिगेशन में. शो कॉज नोटिस, अपॉइंटमेंट ऑफ डिसिप्लिनरी कमेटी. Another important point regarding disciplinary committee is the members of the disciplinary committee shall consist of full-time members only. So no part-time member is entitled to become a member of disciplinary committee. Then there are provisions regarding finance, accounts and audit. Section 221 talks of it. 222 talks of board fund. So it says there shall be constituted a fund to be called the fund of the insolvency and bankruptcy board. And there shall be credited to it all grants, fees and charges received by the board, all sums received by the board from such other sources as may be decided upon by the central government, such other funds as may be specified by the board or prescribed, and fund shall be applied. What is the purpose of this fund? It is applied for meeting the salaries, allowances and other remuneration of the members, officers and other employees of the board. Because actually the board is supposed to be a self-financing regulator. And the expenses of the board in the discharge of its functions under section 196, expenses on objects and for the purposes authorized by the court and such other may be admitted. Accounts of the board are to be audited by C&AG, Comptroller and Auditor General of India, and the accounts shall be audited by CAG, and the report shall be submitted to both the houses of Parliament. Then this we have seen section 224. So this section 224, it talks of insolvency and bankruptcy fund. And in 222, we have seen the board's fund. So board's fund is different. This is the board fund, 222. I hope my screen is visible, huh? And 224 is the insolvency and bankruptcy fund. So both these funds are different. 224 talks of a fund. There shall be formed a fund to be called the insolvency and bankruptcy fund. And the following amount shall be created: the grants made by the central government, amount deposited by the persons as contribution to the fund, amount received in the fund from any other source, and the interest or other income received out of the investment made from the fund. So if an individual wants to contribute, he can contribute in the insolvency and bankruptcy fund. But the board fund actually, which is given in section 222, it talks of grants, fees and charges received by the board, and all sums received by the board from such other sources as may be decided upon by the central government. So basically, the central government is funding or the fees which is given by the insolvency professionals, that is going to the board's fund, which is utilized for meeting the board's expenses, 222. But the section 224, it talks of another fund that is called the insolvency and bankruptcy fund, in which individuals can also contribute. And if a person has contributed to the fund, and suppose his application is admitted for insolvency, then in that case, he can claim the amount not exceeding the amount contributed by it for making payment to workmen, protecting the assets of such persons, meeting the incidental costs during the proceedings or such other purposes as may be prescribed. So section 224 subsection 3 says that a person who has contributed any amount to the fund, suppose there is a company, so he has contributed 10 lakhs to insolvency and bankruptcy fund, but proceedings are initiated in respect of that company. So then that company can make an application to such adjudicating authority for withdrawal of funds not exceeding the amount contributed by it. So suppose he contributed 10 lakhs, that company, so they can claim back 10 lakhs for specific purposes, for making payments to workmen, protecting the assets of such persons, meeting the incidental costs during the proceedings or such other purposes as may be prescribed. And the central government shall by notification appoint an administrator to administer the funds in such manner as may be prescribed. Then section 225 talks of certain powers.
Whether this 224 section has been enforced, sir, now?
No, it has not yet been enforced, but we have to still read this section.
Okay, sir.
Enforcement actually means, because they are saying as may be prescribed, so nothing has been prescribed. That is the only meaning. That okay. So, but we have to read the section as such.
Okay, sir.
Then 225. Huh? Section 225 says power of the central government to issue directions to the board, because the board came into existence by virtue of a notification by the central government. So the central government has the power to issue directions to the board also, and the decision of the central government shall be final. This is what section 225 says. Then section 226 says that in certain situations, the board may be suspended for a period not exceeding 6 months. And there are certain situations which are given. So suppose the central government issued any direction and the board did not comply with that direction persistently, then the board may also be suspended. And the central government may by notification supersede the board for such period not exceeding 6 months as may be specified in the notification. Then section 227. Section 227 talks of powers of central government to notify financial service providers. And they have, by virtue of this notification, they have provided non-banking finance companies, which include housing finance companies with asset size of 500 crore or more, as per the last audited balance sheet, as financial service providers. The appropriate regulator for this is Reserve Bank of India. And so for this financial service providers, we will be having a separate session. We'll take one session exclusively on this financial service providers, which will cover this section 227. Then 228 talks of budget, that the board shall prepare budget for next financial year and forward it to the central government. 229 talks of annual report, that annual report it has to prepare and it has to forward it to the central government. Then 230 talks of delegation. So it says that the board may, by general or special power in writing, delegate to any member or officer of the board, subject to such conditions, if any, as may be specified in the order, such of its powers and functions under this code, except the powers under section 240, as it may deem necessary. So it cannot delegate the powers which are given in section 240. And section 240 talks of the power to make regulations. So this power to make regulations cannot be delegated, but other powers can be delegated. Then section 231 talks of bar of jurisdiction, that no civil court will have jurisdiction in respect of any matter in which the adjudicating authority or the board is empowered. Then section 232, it talks of that members, officers and employees of the board, they are deemed to be public servants. And the definition of this public servant is given in section 21 of the Indian Penal Code. And if you see the definition closely, there is a reference to a liquidator also, which has been appointed by the code. But another question arises, whether this insolvency professional is a public servant. Insolvency professional is not a public servant. Insolvency professional is a privately regulated independent professional. Then 233 talks of protection of action taken in good faith. So if any officer or the government or any officer of the government or chairperson, member, officer or other employee of the board or an insolvency professional or liquidator or anything which is done or intended to be done in good faith under this code or the rules or regulations made thereunder. So even these IPs and this liquidator, they are also granted immunity if they take any action in good faith, then there is a protection granted to them. So for such actions which have been taken in good faith, no suit, prosecution or other legal proceeding can be taken against them. Then 234 talks of agreements with foreign countries. Suppose there are assets or properties of the corporate debtor or personal guarantor of corporate debtor which are situated in a country outside the jurisdiction, then the adjudicating authority, on receipt of an application under subsection 1 and on being satisfied that evidence or action relating to assets is required, so then they will issue, the adjudicating authority will issue a letter of request. So 235 starts that in case of insolvency resolution or liquidation, if the resolution professional, liquidator or bankruptcy trustee is of the opinion that the assets of the corporate debtor or debtor, including a personal guarantor, are situated in the country outside India, he may make an application to the adjudicating authority. And adjudicating authority, what they will do, if he feels so, then they may issue a letter of request to a court or an authority of such country competent to deal with such request. 235A talks of punishment where no specific penalty or punishment is provided. So it is 1 lakh to 1 crore. Suppose you are not able to find that, okay, for this particular offense, no specific penalty is there. So then there is a general clause, 235A. It says 1 lakh to 2 crores. Then 236 talks of trial of offenses, because in IBC we have read that, okay, there are imprisonment provisions also. So those imprisonment provisions, though, they are to be done by special courts. ये नहीं कि सीधा एडजुडिकेटिंग अथॉरिटी से उसको जेल भेज देंगे, यहाँ ये उसका ट्रायल होगा, फिर ट्रायल ऑफ ऑफेंसेस बाय स्पेशल कोर्ट्स। ठीक है, जो अवार्ड ऑफ पनिशमेंट है ना, वो पनिशमेंट की जहां तक बात आती है वो यहाँ पर आएगी। और उस केस में क्या होगा कि जो सेंट्रल गवर्नमेंट की या बोर्ड की कंप्लेंट पर ये होगा। Notwithstanding anything in the code of criminal procedure, offences under this code shall be tried by the special court established under chapter 28 of the Companies Act. ठीक है, जैसे दिल्ली में भी एक स्पेशल कोर्ट है इसके लिए, द्वारका में, इसी तरह से मुंबई में 2 कोर्ट्स हैं, वो कोर्ट्स का पूरा एड्रेस भी दिया हुआ है कंपेंडियम में पीछे, अगर आप देखोगे ना। अच्छा, 237 इट टॉक्स ऑफ अपील्स एंड रिविजन्स। तो इसमें अपील्स एंड रिविजन में क्या बोलता है, द हाई कोर्ट में एक्सरसाइज एज फार एज मे बी एप्लीकेबल all the powers conferred by the chapter 29 and 30 of the code of criminal procedure on a high court as if a special court within the local limits of the jurisdiction of the high court were a court of sessions trying cases within the local limits of the jurisdiction of high court. So there is a limited jurisdiction of this high court. अच्छा, उसके बाद में आता है सेक्शन 238. Section 238 it talks of provision of this code to override other laws. So that the provisions of this code shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force or any instrument having effect by virtue of any. उसके बाद में 238 talks of limitation, that provisions of limitation act will also apply. 239 talks of power to make rules, so central government may make rules by notification. 240 it gives the power to make regulation, and this power cannot be delegated. Okay? Then section 240A. Section 248 talks of applicability to MSME. We have read section 220. We have read section 29A also, and this we have seen that clauses H, C, and H are not applicable in case we are dealing with CIRP of MSME.
Sir, hello sir.
Hello sir. बोलिए.
Sir, in PPRP, submitting the resolution application, the CD can jointly with other person, or he can jointly and submit the application actually for
Okay.
for in this case for the CD it is in a 29A is an exemption actually. Whether the same it is applicable for joint person is that for him also it is applicable. It is an applicable. Is it applicable? I am CD.
Actually, we have to see the applicability of clauses C and H. So if there is a case of say NP of 1 year or 3 years, whatever is given in 29AC, or there is a case of invocation of guarantee which is given in 29A, then these clauses will not be applicable in case we are dealing with the CIRP or this PPIRP of MSME. Both दोनों में. Yes.
Okay.
हाँ.
Yes.
पहले CIRP था खाली, अब PPIRP भी हो गया. अच्छा. 241 says that rules and regulations, they have to be laid before the parliament. Then 242, it talks of power to remove difficulties, that the central government has the power, but no order can be made after the expiry of 5 years from the commencement of the court. Okay. Then 243 talks of repeal of certain enactments. ये दोनों repeal हो गए, लेकिन जो pending proceedings हैं, they will continue. Then 244, it talks of transitional provisions, and section 245 to 255, they talk of the various schedules through which the amendments have been made in various acts. ठीक है, तो ये फिर आपके कुछ इसके अंदर है, क्रॉस बॉर्डर इंसॉल्वेंसी है, और देख लेते हैं कुछ. Yes.
Sir, in this section 231, sir, it says. Take that section, sir. Bar of jurisdiction, sir.
Yes.
No civil court shall have the jurisdiction in respect of any matter, sir. So when we are discussing about that PPIRP case, no, sir. 54G.
Yes.
I think, sir. But case law, whether that and this is how we can correlate, sir, because it says bar of jurisdiction. But in that section, it specifically says that you can go for
Actually,
appeal on
that is the case for willful omission, as far as I remember. That
So
is a
it
case
is
of
criminal.
willful omission. Yes. So willful omission. So
Okay,
suppose
sir.
some deliberately or mischievously he omitted the claims. So in case of willful omission of claims only, and if his interests are prejudicially affected, then only he has been given the right to approach the court. Basically, that is the point.
So
So
in
this code is a
54G, you
special
can
code or
go
normal?
only.
That
So
will
only you can
that
go.
will be as per the jurisdiction wherever he resides or wherever he does business.
Not a special code, sir, in that case.
No, कोई special code नहीं. Special codes are only there for awarding these offenses and punishment. ये जो punishment है ना, punishment के लिए है special codes. Because these are triable offenses. So इसमें trial होगा, उसके बाद में फिर punishment होगा. वो कोर्ट देखेगा उसको, चाहे समरी नहीं देखे. भाई देखो, एडजुडिकेटिंग अथॉरिटी ने अपना ओपिनियन दे दिया कि ठीक है ना, कोई पीयूएफई ट्रांजैक्शन हो गया या कुछ भी हो गया, है ना, कोई भी, जैसे वो सेक्शन 68 ऑनवर्ड्स कुछ पेनल्टीज हैं, 66 से या 68 से 77 तक जितनी भी पेनल्टीज है, और भी जगह पेनल्टीज हैं, तो उसके लिए क्या करना है आपको, फिर स्पेशल कोर्ट में जाना पड़ेगा. वो सेंट्रल गवर्नमेंट या बोर्ड के थ्रू ही जाते हैं.
सर एक बात, ये इस सेक्शन में अपन देख रहे हैं सर, जैसे मान लीजिए कुछ लोग एब्सकॉन्ड कर गए इंडिया से यहाँ मतलब बैंकरप्ट हो करके, तो इनको अगर यहाँ लाना है, प्रत्यर्पण करना है, इंडिया में लाना, तो व्हाट विल बी द प्रोसीजर? कोर्ट टू कोर्ट इट विल कम और गवर्नमेंट विल इंटरफियर इन दैट?
भाई देखो, ऐसा है, उसका क्या है, वो अनसेंट्रल लॉज के अंदर आता है. ये देखो ना, ये क्रॉस बॉर्डर इंसॉल्वेंसी में आता है. क्रॉस बॉर्डर इंसॉल्वेंसी में क्या है, देयर इज अ कांसेप्ट ऑफ म्यूचुअल कोऑपरेशन. कुछ कंट्रीज ऐसे हैं जिनके साथ हमने रेसिप्रोकल अरेंजमेंट्स किए हुए हैं फॉर एक्सचेंज ऑफ इंफॉर्मेशन. कुछ कंट्रीज हैं जो जिनके साथ एक्सचेंज ऑफ इंफॉर्मेशन नहीं है हमारा, ठीक है ना. तो ये क्या है, ये परसुएसिव बेसिस पर होता है, ठीक है ना.
उनके कोर्ट ऑफ लॉ से फिर हम हमारे कोर्ट ऑफ लॉ से उनसे कोऑर्डिनेट करके कर सकते हैं, वैसा हो?
हाँ, कर सकते हैं, क्यों नहीं कर सकते.
गवर्नमेंट की दखल क्या रहती है सर, हमारी सेंट्रल गवर्नमेंट या उस कंट्री की सेंट्रल गवर्नमेंट?
भाई ऐसा है, सबसे पहले तो जैसे अभी हमने क्या पढ़ा, हमने पढ़ा भाई, इफ इंसॉल्वेंसी प्रोफेशनल और रेजोल्यूशन प्रोफेशनल और लिक्विडेटर फील्स, ठीक है ना, दैट सर्टेन एसेट्स आर सिचुएटेड अब्रॉड, ठीक है, उस कंपनी के एसेट्स हैं या पर्सनल गारंटर के एसेट्स हैं, तो ही विल मेक एन एप्लीकेशन टू द एडजुडिकेटिंग अथॉरिटी. नाउ एडजुडिकेटिंग अथॉरिटी विल राइट अ लेटर ऑफ रिक्वेस्ट, लिखा ना उसमें, अभी पढ़ा हमने, तो लेटर ऑफ रिक्वेस्ट डालेंगे उनको, उस कोर्ट को, कि भाई ये करो आप. जैसे जेट एयरवेज वाले केस में हुआ था. जेट एयरवेज वाले केस में क्या हुआ कि उन्होंने क्या किया कि भाई जेट एयरवेज इंडिया में भी ऑपरेट कर रहा था, वहां भी ऑपरेट कर रहा था, वहां के भी कुछ ड्यूज थे, तो उन्होंने क्या किया, उन्होंने कहा भाई ये एयरक्राफ्ट यहाँ से मूव नहीं कर सकते जब तक तुम हमारे ड्यूज नहीं क्लियर करते. अब यहाँ जो आरपी था, आरपी बोला आई एम एंटाइटल्ड फॉर कस्टडी एंड कंट्रोल, तो मेरे को जो है यहाँ पर, वहां पर वो नीदरलैंड्स कोर्ट ने भी कोई जजमेंट दे दिया उस केस में. तो फिर यहाँ की एडजुडिकेटिंग अथॉरिटी ने कहा कि भाई इट हैज टू बी डन ऑन म्यूचुअल कोऑपरेशन, तो आप उनका जो कोर्ट का जो एडमिनिस्ट्रेटर है उसको भी यहाँ अपने CIRP में इन्वॉल्व करो, इस तरह से. तो ये जो है ना, अभी इवॉल्व हो रही है कॉन्सेप्ट जो क्रॉस बॉर्डर इंसॉल्वेंसी वाली. इट इज बेसिकली बेस्ड ऑन द प्रिंसिपल ऑफ म्यूचुअल कोऑपरेशन. रिक्वेस्ट करते हैं, मान लेते हैं, नहीं मानते, अनसेंट्रल के अंदर आता है ये सारी चीजें. ये अनसेंट्रल मॉडल लॉ है ना. तो अब इसमें क्या है, ये देखो, ये क्या है कि इट मियरली ऑफर्स लेजिस्लेटिव गाइडेंसेस. The objective of the law is to assist the states to equip their insolvency laws. ठीक है ना. अब ये कोई, क्योंकि क्या है कि डिफरेंट लॉज है हर एक के, तो ये इसमें क्या प्रिंसिपल्स क्या है, एक्सेस, रिकॉग्निशन, कोऑपरेशन एंड कोऑर्डिनेशन. ऐसा तो है नहीं ना उसको कह दो कि भैया जबरदस्ती लो. इट अलाउज फॉरेन प्रोफेशनल्स एंड क्रेडिटर्स direct access to domestic courts and enables them to participate in commence domestic insolvency proceedings against a debtor. ठीक है भाई, एक फॉरेन सप्लायर है, एक फॉरेन सप्लायर ने इंडियन कंपनी को माल सप्लाई किया, हम इंडियन माल पैसे नहीं दे रहे, इंडियन कंपनी इज नॉट पेइंग द मनी, तो ही कैन डायरेक्टली इनिशिएट इंसॉल्वेंसी प्रोसीडिंग्स. बट बात ये, प्रॉब्लम कहाँ आती है, प्रॉब्लम वहां आती है जब उसके एसेट्स यहाँ पर लाने, वो एसेट्स वहां पर लोकेटेड है, वो ट्रांसफर होगा. अगर मूवेबल प्रॉपर्टी है तो मूवेबल प्रॉपर्टी में वो आपको फॉरेन एक्सचेंज भी इन्वॉल्व है, बहुत सारी चीजें इन्वॉल्व है. इस तरह से अगर इमूवेबल प्रॉपर्टी है तो वो कैसे लाई जाएगी, ये चीज. तो इट अलाउज रिकॉग्निशन ऑफ फॉरेन प्रोसीडिंग्स एंड इनेबल कोर्ट्स टू डिटरमिन रिलीफ अकॉर्डिंगली. इसमें देर आर मेनी एस्पेक्ट्स। एक तो एस्पेक्ट आता है रिकॉग्निशन ऑफ फॉरेन डिक्रीज। सपोज ए डिक्री हैज बीन अवॉर्डेड बाय फॉरेन कोर्ट, अब वो डिक्री क्या इंडिया में रिकॉग्नाइज होगी या नहीं होगी, उसके लिए क्या है, हमारा सिविल प्रोसीजर कोड बोलता है कि भाई वो डिक्री को यहाँ पर रिकॉग्नाइज करने के लिए पहले आपको कोर्ट में जाना पड़ेगा। एज इट इज रिकॉग्नाइज नहीं हो सकती। अगर आप जर्मन कोर्ट की कोई डिक्री ले आए तो वो डिक्री यहाँ पर एनफोर्स नहीं होगी डायरेक्टली, आप कोर्ट के थ्रू उसको एनफोर्स कराना पड़ेगा।
राइट, आई गेट द पॉइंट।
ये चीज है। तो लाइट दोबारा चली गई है मेरे ख्याल। अब इसको यहीं खत्म करते हैं आज, है ना? किसी का कोई क्वेश्चन है तो पूछ लेते हैं, नहीं तो फिर या थोड़ा सा उसको डिस्कस कर लेते हैं, थोड़ी रिकॉर्डिंग स्टॉप कर देते हैं, उस पॉइंट को डिस्कस करते हैं।